Now, as I explained during the legal year opening ceremony, we've been having challenges with criminal justice administration generally, and that is why we are embarking on the justice sector reform. Prosecuting criminal cases involves so many agencies. You see, the process starts with the arrests. Prosecution before a court of record requires that you put your acts together. You need a charge. A charge will state the offense an accused is being charged with, what type of evidence you have, how many witnesses you have, how do you intend to present your witnesses. This will be served on the person accused or his lawyer so that he will prepare his defense. Now, the police and other security agencies will make arrests and start investigation. That may take a very long time. But the requirement of the Constitution is that they must take them to court within the shortest possible time. They take them to a lower court which has no jurisdiction, and then take them there for cognizance. If the offense is capital in nature, they'll keep on going. You know, the police in the first place have the right to grant administrative bail before concluding investigation. Now, they will hurriedly take the case to court and secure the person to be taken to correctional facility for detention. The next step they do is to compile the investigation report and send it to the Director of Public Prosecution, who has the statutory duty to now advise the police from the evidence you presented, from the investigation you gathered. There is a prima facie case revealing element of so offense. Is it rape? Is it kidnapping? Is it armed robbery? Because eventually the Ministry of Justice will prosecute the case before the court, and they will meet lawyers who are equally professionals. And you know, in our criminal setting, in our criminal justice setup, an accused, a charge of a criminal offense has to be proved beyond reasonable doubt. It is the evidence the police gather or any security agency gather that helps to track down, prove to the court that the person you are charging for kidnapping has actually committed the kidnap. Yes, the victim may be there. The other witnesses may be there. Some exhibits may be there. But if you don't handle the prosecution in the manner that satisfies the court that this person actually committed the offense, the court will have no option that at the end of the day to say some doubt is there and we are not certain if this person commits this offense. What happens in between is that it takes a very long time, because probably the police become comfortable when they take it to a magistrate court and the charge is. Now, in the meantime, that accused is a Nigerian. He or his lawyers may come and file fundamental right enforcement that I have been arrested, accused of an offense, but there is no iota of evidence that I have committed the offense because I have not been charged to court for 7 months. And the court will look at it. If the police or the ministry has any reason, they will come over to say, we are still investigation, this is our predicament. But when you have a situation where a person filed for the enforcement of his fundamental right or filed to be granted bail and nobody comes to say, I am objecting because of this reason, the court has only one option, to hear his own side. In some cases, the court, because we are also members of the society, we feel this. Yes, there are some facts you can read from the FIR or his application. Yeah, if there is some element of prima facie case, which is supposed to be done by the prosecution. We refuse bail. After all, it is the discretion of the judge to either grant or refuse bail. And even if a judge grants bail, the police or the ministry still have the right to go to the court of appeal if it is from a high court to say the high court has granted bail which is improper. And this is never been done. It is only when you refuse an accused person bail that he will go upstairs to challenge it. And in most cases, if it borders on fundamental rights, the court of appeal will grant him bail. Look at the recent case of Kanu. What happened? But just on the surface, because his prejudice is still before the court. People may tend to blame the courts, but the courts do work with what is before them. If you accuse somebody, and you cannot prove that he has done that thing, what do you want to use the court to keep on punishing somebody who has not committed offense when the Constitution clearly says that any person that is accused of an offense must be prosecuted without delay? I hope the point is clear. The court is will be too delighted to do its own part to rid the society of evils, because the court is part of an organ of social engineering. If the society is in a problem, the court also is in a problem. But when the court alone cannot do it, it is the pivot. Everybody brings it to the court. Otherwise, why don't the police go and execute a person? Because the universal standard is that if you commit an offense, you must be taken to court. The court must follow due process to prosecute you. The delay that comes in between is what we are trying to address and reform. Police have no logistics to conduct investigation. Okay, we said under the Committee for Administration of Criminal Justice, here is a vehicle for you, dedicated specifically for investigation, with the hope that that will quicken the phase of investigation. We have given you time frame. Investigate within a month, take it to the Ministry of Justice within a specified period. The Director of Public Prosecution should act on those files. They have started, of course, we have started seeing changes because they have now cleared over 300 case files waiting advice. Some of them have no case to answer, they have been discharged. Some of them they have now filed charge before the court. It's for them now to bring in witnesses to prove that charge. And this may linger, may take a very long period of time. One witness has been transferred, he's gone on special duty, he is sick, and even when the administration of criminal justice law says there is a time frame, 1, 2, 3 adjournments, if you cannot call your witnesses, let the case go. Well, the court should go ahead, but the risk is that without the witness, there will be no proof. So you will end up discharging almost every criminal case. So we're also bothered. It's so frustrating. We're also bothered with this agony of having to wait for a long time before you arrive at a judgment. For the problems that we have identified, we're coming together under a committee. The judiciary is there, represented by the Chief Judge as chairman of the committee. The Ministry of Justice is there, represented by the Attorney General. The police is there, represented by the Commissioner of Police. Once a problem crops in, even the Human Rights Commission is there to observe and give in their input. Private bar, Nigerian Bar Association, is there on the committee because on the other side, they have their own problem of causing delay. Now, we sit down and say, look, for the lawyers, we are all ministers in the temple of justice. It's not about the money you get as a lawyer. It's about the justice that is meted out to your client and to the society and to the victim. So you see, sometimes you find that the victims are not cooperating, or their families. But we are trying to address this, enlighten them, do a lot of things out of the box, like giving frame time for investigation, like giving time frame for files to be treated by the Director of Public Prosecution, are all geared towards improving the system. We have inherited a system that did not undergo any reform. It is now in the last 5 years, from 2015, that we have the whole process of reforming the criminal justice system has started. And what wasn't the matter is that crime keeps on growing. In the last 5-10 years, there was nothing like kidnapping, abductions, and it was not so prominent in our laws. All the criminal laws, penal code has to be amended to now reflect the new trend in crimes in the society. In the first 5 years, at least until 2019, the only kidnapping was a minor kidnapping that was not. Abduction was not there. Terrorism was not there until the Terrorism Act was passed, and a lot of things. Cattle rustling was not even in our laws until recently, when the changes were made. So, as the society evolves, sophistication, and in the past, there was nothing in our laws reflecting cyber crimes. It is now common, and it is linked to kidnapping, it is linked to abductions, and it is linked to cattle rustling. Even cyber bullying was not unknown to our laws, but is now a very serious offense. And so the jurisprudence is being developed on those new trends in crimes. Some of them you have never seen them, but they come, and the law is there, the lawyers are there. So together, as ministers in the Temple of Justice, we attend to the problem. But the only thing that one should be hopeful about is that let everybody play his own part, even as a witness, even as a court user, the court staff, and everybody must play. The judge has only one important role: to advocate of the facts before him, apply the law, and come up with a decision. That is the pivotal role of a judge. But it's all heaped on the judiciary. It's not the judiciary alone that is causing the delay. Actually, our hands are tied in the judiciary. Until you have the evidence, you can rush. Justice delayed, of course, is justice denied. But it's useless rushing to deliver justice. I hope you understand. If you can do technical justice, yes. We want to be seen as having disposed of capital cases, but where do they go? We are all human beings. We are constrained by certain circumstances, but the court has to do its work, but it cannot do it alone.